conduct lawmaking business with the exclusion of the senators. I'm now joined by Makueni County Senator Mutula Kilonzo Jr. Senator, many thanks for your time. So the High Court has given 9 months for consideration of some of these things. One of the laws affected by the judgment, of course, is the National Assembly amendment. I beg your pardon, let's take that again. One of the laws affected by the judgment is the National Assembly Amendment Health Laws. Despite healthcare being a devolved function, another law affected by the judgment is the Contentious Computer Cybercrime Act, which tamed bloggers and internet users. So this act recommends a fine of 20 million shillings or a prison term of 10 years or both for harassing a person through the internet by making posts that are indecent or grossly offensive. Other laws are the Public Trustee Amendment Act, the Building Surveyors Act, the Tax Laws Act, the Kenya Coast Guard Service Act, the Supplementary Appropriation Act, the Equalization Fund Appropriation Act. We also have the Finance Act number 10 of 2018 and the Capital Markets Act. Makueni Senator Mutula Kilonzo Jr. now joins me live for the same. Many thanks for your time. The notification now will take effect in 9 months if the National Assembly does not fix the issues that have been raised. But what happens during this period?
The interlude between now and then means that the law has been nullified, and therefore, strictly speaking, under the law, the Senate Speaker and the Speaker of the National Assembly ought to take action immediately to ensure that these pieces of legislation they've received the necessary concurrence for purposes of fulfilling the Constitution. What the court was simply saying, and it's important that Kenyans understand, that the legislative process of any bills under the Constitution begins with the concurrence of the National Assembly Speaker and the Senate Speaker. The determination as to whether it is a matter concerning counties, a matter does not concern counties, it's a special bill, must be done in advance. Therefore, the court has, in so many words, said that Speaker Muturi does not have the unilateral decision, whether he's a lawyer or not, whether he understands the law or not, to take that decision without the concurrence of the Speaker of the National Assembly. It also gives an onerous obligation on the assenting authority, the President, to ensure that he checks that Article 110(3) of the Constitution has been complied with. And most important for us as senators, because we have wasted a lot of time drafting bills. Senators have 40 bills pending in the National Assembly and Senate. Most importantly is the confirmation that the Supreme Court advisory opinion of 2013 is not an advisory opinion, it's binding on the Speaker of the National Assembly and of the Senate. So that process of lawmaking that is mandatory, it cannot be ignored. And the standing order of the National Assembly, which easily, in a process where we have made so many laws, senators are extremely frustrated by the National Assembly, I must say this. And when bills are passed through a very long, rigorous process, there's, the National Assembly has a standing order where they declare them money bills, in effect saying that you should not have started this process at the first instance. So this is a victory not only for Kenya and not only for the Senate, it's a victory for devolution, because this was a very deceitful way, so to speak, of clawing back on the functions of national government, functions of counties. And interestingly, the Supreme Court in 2013, in paragraph 102, said something that I've repeated on the floor of the Senate, and I've said it. It says, with a good speaker, they will find something about security that concerns counties. They will find something about public finance that concerns counties. Because the counties in Kenya do not exist in the air. The country is divided into 47 counties. So the two speakers have an obligation to find a matter on security in Isiolo, in Meru, etc., even if it's not a national, it's not a county function.
What happens in 9 months, Senator, if there hasn't been a resolution? Because, I mean, we've seen so far senators embroiled in a long-standing dispute with members of the National Assembly over the role of the Senate in matters legislation. And we've also had the National Assembly, on the other hand, claiming senators are overstepping their mandate and duplicating their roles of Parliament. So what happens in 9 months if there really is no resolution between these two houses?
The court has already given what would be what we call a sunset clause. If you do not comply with 9 months, the laws are nullified.
And what impact would that have on
Simple.
Kenya?
That law does not exist. It's that simple. It's void ab initio, it didn't exist, it's a mirage. So it is the obligation of the two speakers, majority leader in both houses, to ensure that we do not get to a situation where you have a gap because they don't want to talk. And I've said this before, unlike other jurisdictions, the leadership of the National Assembly and Senate, including the Speaker, come from the same party. In other jurisdictions, you find the Speaker of the Senate, or the name they use for the upper house, is a member of the opposition or minority.
Let's talk about the claims,
the drafters
Senator,
of this constitution.
Let's talk about the claims of the Senate overstepping its mandate and duplicating the roles of Parliament. Do you support the Deputy President's assertion that the Senate powers ought to be increased?
It's not powers. It's not powers. It's just jurisdiction. Means in a presidential system, the executive does not sit in the House of Representatives or what we call the National Assembly. That is the case in France, the case in Germany, and the case in the US. Where you have the executive now in the proposed structure, a prime minister, deputy prime minister, who is a member of the executive, then you need another house to be the check of that House of Representatives or National Assembly and the executive. So that's what happens in the Congress. You know, we are trying to reinvent the wheel.
What will it take from where you stand?
So you can't water down one house.
What will it take from where you stand to resolve the incessant turf wars between the two houses? We've seen, you know, several issues, even with the Division of Revenue Bill, the supremacy wars, sibling rivalry between these two houses. What does it take to solve it once and for all?
It's not what it takes, it's that the country must accept that we have a bicameral legislature. This country has, I was elected by 324,000 Makueni residents. But by ignoring the Senate, they are ignoring the people of Kenya who put us there. We are directly elected. We are not appointed senators. And therefore, in all aspects concerning the country, the people who elected us want the voice of the Senate in those decisions, including public debt. So there must first be political will, and two, culture change. A complete paradigm shift of involving the bicameral legislature in what we call